Appreciating the argument of the defense, the state respectfully asks the court to deny their motion for directed verdict in its entirety and on each and every ground. I will note a few things, and then I know the court has been paying attention and has taken note of the evidence that's been presented. Mr. Chalmers raised several issues in grouping, so let me address them in grouping. As far as the circumstantial or the alleged circumstantial nature of the state's case, it's up to a fact finder to determine the reasonableness of the hypotheses that could be presented to explain the defendant's guilt or innocence. And the evidence that the state has presented to the court and to the jury in this case more than establishes the defendant's guilt on each and every element of each and every count in the indictment. Mack is the case I'm thinking of, M-A-C-K versus the state. It's at 290 Georgia 428.
Did you? I know Mr. Chalmers was nice enough to give me a written motion. Did you have a written response by any chance, or are you just going to?
I didn't do a written response overnight, Your Honor. I'd be happy to.
No, it doesn't have to be. Because we're going for it right now. I just want to be able to follow along because I was able to take a look at his. So.
I know, and it was very nicely done. It was very lengthy, very nicely done. I do have a case for the court, though, the Mack case. I just cited 290 Georgia.
So what's that, 290? Because Ms. Jeffries didn't have a chance to pull that one. So what's that case number again?
I have a copy for the court as well. 290 Georgia 428.
428. No.
2012 decision.
You may approach with my
Thank you, Your Honor. That's just identifying that it's up to the finder of fact. Thank you, Your Honor.
Thank you.
Finder of fact to determine the reasonableness of the hypothesis.
And Mr. Chalmers, do you have a copy of her case?
No, sir, I do not.
All right. Would you have a copy for him by any chance?
I don't, but I will provide them for you.
All right. You may continue.
Thank you. As to the perjury counts, both the materiality and the corroboration that's required, perjury requires two witnesses or one witness and corroborating circumstances. Is it 290 Georgia 428? Thank you. 172. The case I'm thinking of, Your Honor, is Dixon versus the state, and we'll have somebody print out a copy for Mr. Chalmers, 803.
He said he has that one, and Ms. Jeffries has probably pulled up for me also. Go right ahead.
Or one witness in corroborating circumstances, and the weight and the sufficiency of the corroborating circumstances is entirely up to the fact finder. That's Dixon versus State, 172 Georgia Appeals, 803. It is entirely up to the fact finder what it would be that corroborates the materiality. Each of the issues that the perjury allegations in the indictment are contradicted by the defendant's own statements, by her statements either orally to the police or in emails that have been submitted to the jury. They are contradicted by the correspondence, the email correspondence between her and Hemi Newman. They are contradicted by eyewitnesses and other outside witnesses independent of her own words. There is sufficient corroboration as to each of the perjury counts. In particular, I want to address the allegation or the challenge to the term romantic and what that means and how a jury could interpret that and what they should interpret it to mean. Romance is a word of common use and understanding. Romantic is defined as marked by expressions of love or affection. That's coming from the Merriam-Webster Dictionary. Love and affection. There is evidence before this jury that the relationship between Andrea Sneiderman and Hemi Newman involved. It was physical. There was kissing, dancing, groping, etc. It was sexual in nature. Those are statements coming through Mr. Newman to his friend Melanie White, describing various physical acts that the two engaged together. It was emotional. There was testimony, there was evidence that Mr. Newman was in love with Andrea Sneiderman. There was testimony and evidence that they considered themselves soulmates. There was testimony and evidence in Ms. Sneiderman's own words that she felt desire for Mr. Newman. There was an email that referenced desire versus reality. She talked about betrayal of everyone she loved. She talked about anger at what they had done. There was statements and emails indicating that the two woke up together in Denver, that they gazed at the stars in Tahoe, that she nestled her head against his shoulder. All of these things are information in front of the jury that no reasonable person, I believe, defense is free to argue whatever they want to argue to the jury, but as far as sufficient evidence that there was a romance between the two of them, that their relationship extended into expressions of love and affection, I think there's more than enough evidence to submit each of the charges that reference a romantic relationship to the jury. The materiality of the perjury, Mr. Chalmers challenged the materiality of the statements. The state has charged this defendant with committing perjury in several particulars, in that she, then you count 4 that she didn't know that Rusty Sneiderman had been shot at the time she spoke to Donald Sneiderman prior to her arrival at Dunwoody Prep. Not only is her statement, as was presented to the jury, that she didn't know until she got to the hospital. That statement was contradicted by the testimony of Mr. Sneiderman. It was also contradicted by the phone records indicating that her conversation with Mr. Sneiderman, 1, took place, and 2, took place prior to a time that she arrived at Dunwoody Prep, prior to a time that anyone could have or did tell her that Rusty Sneiderman had been shot. Coloring all of the counts in the indictment as far as the defendant's intent, what she intended, what she did, and why she did it, the defense argument ignores a primary part of the state's evidence. The defendant had foreknowledge that Rusty Sneiderman was going to be shot that day. She had foreknowledge of it. She knew it. She knew it. She knew it before anybody told her. She had foreknowledge.
I'm going to object to that. What evidence establishes that point?
All right. I'm going to ask you the same question that I asked Mr. Chalmers. Well, different question, but what in the record indicated that she had, quote unquote, I understand your argument, but just refresh my memory from the record.
The argument and the
That she had
evidence
foreknowledge.
that no one told her Rusty Sneiderman had been shot prior to the time that she told Rusty's father that he had been shot. The implication and the conclusion to be drawn is that she had foreknowledge of the shooting. No one told her. There was no opportunity for anyone to tell her. There's no way else she could have known unless she knew it was going to happen. That is the state's evidence. That's what's in front of the jury. And that's, I believe, colors everything that the defense has argued or tried to argue to the court about the defendant's intent in doing the things she did, concealing the relationship she did with Hemi Newman from the police. It's not a matter of semantics. I think a verbatim what she said, what she concealed from the police. It wasn't just that she didn't tell them everything, it's that she misled them. When she told them that Hemi Newman made a pass at her and that was it, and he read her a poem and she shut him down and that was all. I'm paraphrasing the various interviews. And she said that was all. That was not the truth. And it wasn't just that it wasn't the complete truth, it was that it misled them. She covered up and she misled and she denied the motive for the attack, why he would shoot her husband. And she suspected him, if she didn't know that he did it beforehand, she suspected him immediately per the testimony of Shayna Citron, and even confronted him, asked him about it the day after the murder. Every step she took after that was in concealing his motive for the crime, and concealing the reason why he would shoot Rusty Sneiderman. And her actions are colored by that knowledge. West is the other case I cite to the court. It's 228 Georgia Appeals 713.
228 Georgia Court of Appeals 713?
Yes, Your Honor.
All right. You may continue.
When the defense challenges the materiality of Mrs. Sneiderman's testimony that she didn't kiss Hemi Newman, despite the evidence that she did, that she didn't kiss Hemi Newman in a nightclub in Greenville, there are 2 reasons why it is material, 2 reasons why all of the testimony, as alleged in the perjury counts, is material. It's material because it went to her credibility, and the case I'll provide to the court, West, Mr. Chalmers, someone is going to print that out to you and bring it to you. Thank you. May I approach you?
You may approach.
And there's also Dixon case, I believe you said you already have it.
Thank you.
Any statement that goes to the credibility of a witness in the case is material for the purposes of perjury. Mrs. Sneiderman testified on various issues, and one of the issues that was the subject of her testimony was the motive of the defendant, in that case, Hemi Newman, to commit the crime. Mr. Newman's defense at trial, as is represented in the pleadings that was presented offered into evidence in the state's case in chief, the defense of Mr. Newman was that he was mentally ill at the time, that he was under the throes of a delusion when he shot Rusty Sneiderman, and that was the cause. That was his motive in the crime. Mrs. Sneiderman's testimony supported the fact, or supporting his assertion that there was no romantic relationship, there was no affair. He had no real motive to kill Rusty Sneiderman. He must have had a delusional one. Was absolutely material to the issues at trial. That was essentially, as Mr. Sneiderman testified before the court last week, that there was a dispute about what was the real relationship between Hemi Newman and Andrea Sneiderman, and that was a material issue at that trial. There was a dispute about whether Mr. Newman's relationship with Ms. Sneiderman was real or the product of a mental illness. That was in dispute. So her statements that supported his assertion that the romance was not real, when in fact it was material to every issue at that trial. It was the material issue of the trial. And so any statement that she said that supported Hemi Newman's defense and undercut the real motive for the crime was in fact material. Your Honor, I'm very happy to address any other particular count or particular question that the court has. Otherwise, the evidence, the defense argument is entirely based on the most favorable interpretation of all evidence in a light that favors the defense. And of course, that is just not the standard on a directed verdict. The state presented evidence to establish each and every element of the crimes charged, and it is up for a jury to determine if they were sufficient or not. So we'd ask that you deny the defense motion for directed verdict.
All right, Ms. Cross, before you take your seat, I'm looking at count 8.
Yes, sir.
In particular, and I may refer to some others, but it says, did knowingly and willfully make a false statement during an official investigation into the murder of Russell Sneiderman, to wit, she told Detective A. Thompson that she had made it clear to Hemi Newman that she did not want him to pursue her romantically. And the basis of this charge, and just refresh my memory from the evidence, the evidence that came through the trial will support this particular claim. The quote unquote, she made it clear to Hemi Newman that she did not want him to pursue her romantically?
The series of questions, the audio tape of the entirety of the interview was played before the jury.
It was.
19th interview. The portion specifically that would support states the count 8 of the indictment. There was a question. She volunteered that when asked if there was anybody who was interested in her, she said Hemi Newman. I'm sorry, I don't have the transcript right in front of me, but in paraphrasing, the conversation between the two of them was that he made a pass, that she rejected him, and that was all. There was conversation later among her mother and the defendant, but that's her mother and the detective. That's not what the state's relying on for the charge. The state's relying on the defendant's own words, and her own words is that she had made it clear. They asked her, did you make it clear? Or was it clear? Something to the effect of, did you make it clear? Was it clear? And she said that yes, it was. So that's the testimony. The state's believes that the evidence of the audio tape interview supports that count, and it is I think directly contradicted by the evidence that there was.
Yeah, and I understand you. But I'm trying to, the way this is drafted, it says the offense of false statements in matters within the jurisdiction of the Dunwoody Police Department in violation of Official Code of Georgia 16-10-20 for the said accused person in the county of DeKalb, state of Georgia, on or about the 19th day of November 2010, did knowingly and willfully make a false statement during an official investigation into the murder of Russell Sneiderman, to wit, she told Detective A. Thompson that she had made it clear to Hemi Newman that she did not want him to pursue her romantically.
And that is the false statement, Your Honor. I mean, that's the substance of her answer to the Dunwoody Police Department when they were discussing Hemi Newman, and that is contradicted by all of the evidence that they, in fact, did have a romantic relationship, that she didn't make it clear to him that she didn't want him to pursue her romantically.
I get, and I understand what you're saying, but if she, like I said, I thought at one point during that interview, she said she had made, quote unquote, she had made it clear to him, but is it possible that someone could make a statement at one juncture in a relationship if it's ongoing and then change their mind later? Does that make it a false statement? That's the point I'm trying to make.
I understand, and I appreciate that point. Let me put it in context. When the defendant was talking about how Mr. Newman at one point had made an advance towards her, she was talking about, or told them, meaning the Dunwoody Police Department, that event happened in Minden, Nevada, that they were at dinner, that he read her a poem, that it happened in Minden, Nevada. Since that time, in fact, immediately after that time, in the days after the trip, the state submitted evidence that there was, that was the time that Mr. Newman sent flowers and chocolate to her hotel room, that she was read a note indicating that Hemi Newman loved her, and that she blushed modestly, that they shared a hotel room together in Longmont, Colorado, that he flew out to meet her, and that they went home together. All of the things that established she, in fact, did not make it clear to Hemi Newman that she didn't want him to pursue her romantically. And in proximity to the event that they described, or they were talking about, the event in Minden, followed just recent, within days, that the state's evidence is she did not make it clear that he didn't want her to pursue him. She did not want him to pursue her romantically, and in fact, she reciprocated in the romance. That's the state's evidence that contradicts the defendant's statement on the 19th of November. And whether the jury finds it, beyond a reasonable doubt, or whether they find it convincing is something for the fact finder. But there is evidence in the record that establishes the elements of the false statement count. She made those statements, they were false, and now it's up to a jury to decide if she's guilty of that offense.
All right. Next question I have, as far as count 9, the way
Yes,
this is
sir.
drafted, it said for the perjury count, to wit, that she did not share a hotel room with Hemi Newman in Longmont, Colorado, such statement being material to the issue surrounding the murder of Russell Sneiderman. Refresh my recollection, what evidence came forward that they actually shared a room?
The two were checked in together or she checked in and the occupancy of the room was identified as 2. There's no evidence, in fact, there was evidence that Hemi Newman did not himself have a hotel room in Longmont, Colorado during the period of time, July 21st and 22nd of 2010. Per the cell phone records, they were together, at least their phones were pinging in the same general geographic
Which
location.
is a range, a mile and a half range, is that?
It was, and there was testimony that in no hotel in a 5-mile radius where the two was Hemi Newman registered himself. He was not registered in the Hampton Inn. The two did not travel. The 2 phones stayed in the same general location, meaning the same cell site, tower, and sector for almost the entirety of the time that Mr. Newman was there, with only a 10-minute, 20-minute or so departure when Mr. Newman apparently went out by himself. There was also testimony that Mr. Newman's phone called a takeout Chinese delivery place that delivered to the Longmont Hampton Inn, and that Mrs. Sneiderman expensed that dinner on the 22nd of July 2010. There is evidence that the defendant picked up Mr. Newman from the airport, brought him back to Longmont. There's no evidence that she took him anywhere else, no evidence that he went anywhere else. And the fact that he being Mr. Newman, told the Longmont Hampton Inn Hotel that he intended to meet who he described as his wife, Andrea Sneiderman, at their hotel later on in the week is sufficient to establish that, circumstantially, that the two did share a hotel room together in Longmont, Colorado. He isn't anywhere else. He sent her flowers and chocolate saying, "I'm coming out." He booked a flight. They flew home together, and their cell phones, at least, were together for almost the entirety of the time he was there. There's no other hotel room for him. That is a reasonable deduction from the evidence that this jury could draw.
All right. Count 10 makes reference to they normally make a false statement to Lieutenant D. Barnes and Deputy Chief D. Size, to which she denied that Hemi Newman was in Longmont, Colorado in July of 2010 with the accused. As Mr. Chalmers pointed out, wasn't the question, was he in Denver?
The trip, they talk about Denver. I'll point out 2 things about Denver versus Longmont.
You may.
The first is a clip of the testimony of the defendant that the state played. There was a discussion with the defendant about, well, you said Denver, did you mean Longmont? Yes, when I say Denver, I mean Longmont. That was a testimony that was played. It was during the cross-examination. It was Mr. Peters asking, or I'm sorry, Mr. Rubin, I believe, asking the question ever. So there is some evidence in the record that Longmont and Denver were synonymous as far as the defendant's conversation when she talked about training in Longmont versus flying into Denver. Also, a transcript of that portion of the interview, and I'll just read it verbatim to the court.
You may.
Lieutenant Barnes asked, "Did you make any trips this year by yourself without him being Hemi Newman?" The defendant answered, "I had training Denver, auditor training class." I'll interject that the defendant refers to it as Denver in here, similar to her testimony during the trial court. The training actually was in Longmont, but the two both flew in and out of Denver. Lieutenant Barnes had asked, "In Denver, what?" The phone rings. The defendant answers, "That was July also. It was like the week after Minden. I remember because my husband had to do 2 weeks like by himself, with the kids almost in a row. I came home for a weekend, and then I just sort of had to leave again for this training class." Lieutenant Barnes again, "You didn't say Hemi was not in Denver?" "No, I mean, not that I know of." That was the language. So given that the defendant treated Denver and Longmont as interchangeable for the purposes of this trip, they flew into Longmont and her actual class was in Longmont. The conversation as per the defendant was Hemi was not in Denver with me at this audit training class. An audit training class, the evidence was actually in Longmont, Colorado. So given the explanation she had, the interchangeable use of Longmont and Denver, and the testimony as it was, the transcript as it is, and as the jury heard the audio recording and the video recording of that interview, the state's evidence is sufficient to support count 10.
All right. Count 13 reads, to wit, the accused testified that it was due to her mother's, Bonnie Greenberg's, concern for the accused's safety that she did not immediately report her suspicion of Hemi Newman's involvement in the murder of Russell Sneiderman to the Dunwoody Police Department, such statement being material to the issues surrounding the murder of Russell Sneiderman. Why should this count go forward?
This count should go forward, Your Honor, because the evidence before this jury supports it. It supports it in one, the clip of Andrea Sneiderman's sworn testimony was that she didn't go to the police after she received what she described as a bizarre email from Hemi Newman, which caused her to suspect him. That she didn't go to the police because her mother was telling her he was going to come kill me, he's monitoring our phones, etc. Her testimony, in addition to that, was that she didn't contact police immediately because she herself was concerned about her safety. That she didn't know if he was in Florida at the same time as her. He might be monitoring her emails. She could be monitoring her calls. That she declined to come forward for that reason. The testimony actually was, while Mrs. Greenberg had a recollection when she was on the stand that she had a similar conversation with the defendant in her prior sworn deposition, which was admitted as an inconsistent statement and available for substantive evidence. She admitted that that Andrea Sneiderman had not described the content of the email to her at all. She didn't recall that there was any conversation about any suspicions or any concern or any fear of Hemi Newman. And given that directly contradictory evidence, as well as the circumstantial evidence of when she being the defendant, spoke to the police on January 4th, 2011, the next opportunity when she did speak to the police after receiving what she described as a bizarre email that caused her to suspect him. So bizarre that she was concerned he was monitoring her whereabouts and her communication, that she didn't tell them at the time. She didn't tell them about the email. She didn't tell them about her suspicions. She didn't tell them about her fear. She didn't tell them anything that would support what her testimony, in fact, was, that at that time she believed or she suspected it was Hemi Newman, and that it was only fear that drove her not to go forward and notify the police.
All right. Thank you.
Thank you.
Anything else, Mr. Chalmers?
Yes, Your Honor. A few things, Your Honor. First off, we need to be very clear on what the standard of your review at this point is of the sufficiency of the evidence. The state proffered that they are entitled to all reasonable inferences in their favor. That is actually not the case. That is the standard of review on appeal following a conviction. There is case law that has muddied that issue, and I will give the state that. But the case that describes it best is James versus State, 316 Georgia 406, 2012. I apologize, I do not have a copy of that case with me.
I will have Ms. Jeffries copy it, and we'll copy to all lawyers.
That opinion, Your Honor, states that at this level, when the trial court is considering a directed verdict for acquittal, that you follow the standard in the statute. Is there conflict in the evidence, and the evidence and its reasonable deductions and inferences demand a ruling in favor of the defendant? The standard that the state is entitled to all inferences and deductions in its favor is on appeal after a conviction. Mrs. Cross, and I respect the fact that she hasn't had a chance to review all of our briefs. She did not have a great deal of time to read all those overnight. I understand it. But she made a couple of comments to which I would like to respond. Number one is that she said it's up to the jury to decide the sufficiency of the corroboration. It's always up to the jury to decide the elements of the offense. That does not mean that this court can simply pass it on to the jury if they have failed to meet their evidentiary burden. Your Honor must first make that determination. You must do so by applying the statute to warrant a conviction on circumstantial evidence. Every other reasonable hypothesis must be excluded. Mrs. Cross got up here and talked about the sharing a hotel room, the evidence of sharing a hotel room. Well, gosh, their phones were pinging off the same city. It's undisputed that he went out there for a period of time. They went to the same restaurant for dinner. She picked him up at the airport. Maybe that supports a reasonable inference that they shared a hotel room. Maybe it doesn't. They cannot basically present this case to the jury on the grounds that one reasonable hypothesis may be that they shared a hotel room. To send this woman to prison, they have to prove that that is, in fact, what happened and that she lied about it. They have failed to do that.
Mr. Chalmers, I didn't stop you before. You keep making references to quote-unquote prison. As you know, we're at the point of seeing whether or not the case goes to the jury.
Understood.
We're not even, I mean, so it's not, I don't think it's necessarily talking about possible punishment. Let's just deal with where we are right now.
Your Honor, I didn't mean to suggest that procedurally we are there. They're attempting to impose criminal liability on her for that, regardless of what the sentence might be if that was proven. My point is they cannot convict her for that crime without proving that fact. They have not done so. In their argument, the state pointed out that Mrs. Sneiderman's allegedly perjurious statements were contradicted by her own statements. That was a direct quote. That is a violation of the Dixon rule that you may not prove perjury by a contradiction in the defendant's own statements. The Merriam-Webster dictionary definition of romantic was cited. That to me is fascinating. If you look at that dictionary, and I have, there are probably 8 or 9 different definitions of the word romantic. They include fanciful, other terms like that. The state cannot prove how the defendant interpreted the phrase, and therefore it cannot prove its case. The state also said that there is evidence in the record of a romantic relationship, and they cited flowers and chocolates sent by Mr. Newman. They cited notes about love sent by Mr. Newman. Marry me sent by Mr. Newman. Where is the email saying from Andrea Sneiderman, marry me? Whereas the testimony of somebody saying Andrea really loved Hemi Newman. It's not in this file. It does not exist. The state also misstates the evidence. That email where Hemi Newman says, we woke up in Denver, does not include the word together. The state has over a year been saying the email from Hemi Newman says when we woke up together in Denver. It doesn't use the word together. This is a perfect example of what has gone on in this case. Things that Andrea Sneiderman said or that Hemi Newman said have been interpreted by the state a certain way and presented as fact. That is not in that email. And in terms of what evidence, and this really is the crux of their case, she knew in advance. What do they have as evidence that before she got to Dunwoody Prep, Andrea Sneiderman knew that Rusty Sneiderman had been shot? Solely the evidence of Donald Sneiderman. Donald Sneiderman says one thing about the call. Andrea Sneiderman says another thing about the call. That is one witness against one witness. It is insufficient as a matter of law to support a perjury conviction. So what evidence does the state have to corroborate it? Testimony about the time that the phone call occurred and testimony that Andrea Sneiderman was not yet at Dunwoody Prep when the call occurred. That tells us that the call occurred. That is undisputed. That does not corroborate his version of what was said in the call. That is insufficient corroboration to allow this even to go to the jury. On the materiality issue, the state has cited statute or law which basically states that an issue is material in a case if it is material to the credibility of a witness. That is, in fact, correct, if that witness testifies on a material issue. In order to apply that rule, the state must first prove that the witness testified on a material issue. They must proffer sufficient evidence to the jury to prove that that issue was material in the previous case and that the defendant's testimony was material to it. They have failed to do that. Let's talk briefly about materiality as to some of these counts. And I won't repeat everything I have said, Your Honor. I'm going to go to just a couple of them.
That's fine. I was going to say, if you said it earlier, you can assume that I heard you the first time, but you don't have to accept that assumption.
Yes, sir. The only one I will focus on, Your Honor, was the last one which you asked about, which was the testimony that Andrea Sneiderman did not, or the allegation that Andrea Sneiderman did not immediately report her suspicions to Hemi Newman after she became suspicious on December 28th when she's in Florida, did not report that till January the 4th when she got back to Georgia over the New Year's holiday. Excuse me. How is the issue of when Andrea Sneiderman first suspected Hemi Newman and whether or not that was before or after December 28th remotely material to the issues in the Newman case in deciding whether or not Hemi Newman had a mental disease or defect or knew right from wrong at the time he murdered Rusty Sneiderman months earlier. That's just one example of the fact that these statements were not material. We respectfully submit that the state has not proved its case, Your Honor, and we would ask that the motion be granted.
All right. All right, lawyers, what I'm going to do is take a brief recess and consult with Ms. Jeffries, my staff attorney, and I will come back and render a ruling. Deputy Garrett, there'll be a brief recess.
All rise.